year is 1993. A 62-year-old woman is found dead in her home in Germany, strangled to death by a wire. Police have no clue as to who did this or why, until they swab a teacup in the house for DNA, and analysis reveals it belongs to an unknown woman. 8 years pass when, in 2001, a 61-year-old man is found dead in his home, also in Germany, also strangled to death. DNA found on a kitchen drawer in the house is an exact match with the unknown woman from the previous strangling. A few months later, on a German playground, a 7-year-old steps on a discarded syringe. What sort of animal leaves their dirty needles in a children's playground? The unknown woman DNA analysis would reveal. A few weeks pass when a caravan is broken into and burgled once again in Germany. At the scene of the crime is the leftovers of a cookie on which the unknown woman's DNA is found again. Over the next few years, her DNA is present in all manner of crimes in Germany. It's found in abandoned stolen cars. It's found on bottles in a burgled bar. It's even found on a bullet. A man got into a fight with his brother and shot him. An open and shut case. Man has gun, shoots brother. However, her DNA is on the bullet. In total, her DNA is recovered from around 40 crime scenes in Germany and into Austria and France as well. She was referred to by investigators as the Phantom of Heilbronn, or the woman without a face. It was later discovered that the woman the DNA belonged to, that was found in more than 40 crime scenes across several different countries, was factory worker at the plant that produced the cotton swabs used by forensic teams to swab the evidence. A simple touch from the factory worker was enough to send investigators in the wrong direction from over 40 cases. Could a simple touch from a factory worker on a knife sheath damn an innocent man in America as well?
Ladies and gentlemen, thank you.
Listen to Pavarotti.
Can I be your superhero?
In cases involving DNA recovered from a suspect at a crime scene, everything must work right. From the collection of evidence, transportation of the evidence, time frame from collection to the extraction, then processing of the evidence. Forensic analysts must then contend with obstacles such as DNA degradation, processes such as PCR amplification to enhance the DNA for proper matches to perpetrators. Any errors in the process could lead to wrong interpretations known as confirmation bias. If everything is done correctly and a suspect is identified through the course of the law enforcement investigation, then a comparison is done and an RMP, random match probability statistic, is generated. This is known as the likelihood ratio. It compares the match to the suspect against the probability of it being the suspect rather than a random individual selected from the general population. Any errors or deviation from the steps in this process can lead to the ultimate wrong conclusion and convict an innocent, as has happened in so many documented cases in the past. Enter the equation of the new technique of investigative genetic genealogy, a method that searches for a suspect with the use of the genetics of the crime scene sample to identify the suspect rather than the traditional method of investigators identifying the suspect first. And now you've added a step that, in the right set of circumstances, could spell disaster. Consider the implications of using the method of eliminating the genetic markers of the entire population down to just the markers of a specific family lineage to identify a suspect, and the wrong person in the family lineage is selected. Forensic analysts that have no experience with this new method may use their traditional RMP to generate a statistic compared to the general population, rather than the kinship formula that accounts for the comparison of relatives' DNA. Couple that with the fact that the evidence collected from a new item, according to experts from the defense and the state, they both quote, "The knife sheath was new and unused. It may have been purchased for this event." Couple that with the previous mention of the case of the woman without a face that perplexed investigators in Europe for over a decade, when they discovered that a simple touch from a factory worker was responsible for the DNA collected at over 40 crime scenes. Considering the newly discovered evidence proving that one of the only two pieces of real evidence against Bryan Kohberger has now been revealed to be completely wrong due to wrong conclusions, errors in simple math, adding minutes to video timestamps, misidentification of features on a vehicle, the piece of evidence that remains being a minuscule 168 picograms of DNA found on a movable object at the crime scene. If there were any questions whatsoever about the legitimacy of the DNA, then how could any judge accept a guilty plea, and how could any American citizen allow that judge to accept it? Well, it's time to raise those questions about that DNA. DNA degradation. The first question one must ask is, how would DNA degradation affect the analysis of the sample extracted from the sheath at the crime scene? What is DNA degradation? It is the fragmentation and chemical alteration of DNA molecules into smaller, broken strands caused by environmental stress such as heat, high humidity, ultraviolet light, time, and fluctuating temperatures. Degraded DNA poses significant challenges in forensics. Specialized PCR kits, polymerase chain reaction kits designed for smaller target fragments, are used to overcome the degradation. However, degraded samples often come with contaminants that inhibit the polymerase enzymes, requiring specialized purification. In the Kohberger case, redactions make it impossible to verify the extent of degradation that may have existed in the small sample analyzed before the PCR amplification was performed. However, unsealed documents give us a window into factors that can be quantified. The investigators suspect the crime on King Road happened between the times of 4:07 and 4:20 a.m. on November 13, 2022. An 8-hour lapse in time between this event and a call placed to 911 by roommates of the victims, a lapse never adequately explained to many, put the investigators in the case behind those 8 hours. It wasn't until late afternoon that lead detectives from the Moscow Police Department and the Idaho State Police document even seeing the sheath in the home. Police reports document that the sheath was collected as evidence and taken to the Moscow Police Department the evening of November 13th and stored in a temporary storage locker at the department. It wasn't until the morning of the 14th that is documented to have actually been entered into evidence at the MPD. 2 days would pass until the sheath itself was transported to the Idaho State Police lab in Meridian, Idaho, and checked into evidence. The next day, the sheath was finally swabbed for the only sample in the entire case that would later claim the match to Bryan Kohberger. Considering the nature of such a small sample of DNA, likely from skin cells, almost 5 full days between finding the sheath and the actual swabbing for evidence, 3 different locations for storing the sheath prior to the extraction, we can only assume that degradation of the DNA would have likely occurred. This could have a domino effect on the PCR amplification that was later performed, according to lab manager Ryleen Nolan at the Idaho State Police Lab, that could dramatically impact the later match statistics derived from the comparison of Kohberger's buccal swab to the crime scene sample.
All we do is build infrastructure and technology to help identify victims from crimes or perpetrators from crimes from DNA evidence that previously couldn't be used.
Othram, headquartered in the Woodlands, opened in 2018. At that time, a team of 4 people started solving murder mysteries. A few hits a month turned into several solves a week. Today, Othram cracks multiple cases a day.
We've been able to solve contemporary cases in a matter of 2 days and get that perpetrator off the street in a couple days so that they can't commit the next crime. There are still law enforcement departments in this country, many, that don't even know this is a possibility.
Middleman notes cost and lack of success metrics are barriers.
If you went to a doctor and they had a cancer treatment that worked 2% of the time or one that worked 98% of the time, and they chose to use the 2% of the time on you but the 98% of the time on someone else, that would be malpractice.
Can you talk about the role, if any role, Othram has played in major cases across the country, such as the college students killed in Idaho?
Yes, we have played key roles in many of these high-profile contemporary cases. Some are already announced and some aren't. If you went to a doctor and they had a cancer treatment that worked 2% of the time or one that worked 98% of the time, and they chose to use the 2% of the time on you but the 98% of the time on someone else, that would be malpractice.
98% of the time is a strong metric. But what happens with the other 2%? Forensic genetic genealogy is a new method now used by law enforcement to reverse the investigative process. Instead of finding a suspect through boots on the ground investigating, they search for the suspect first through their shared family genetics. The companies such as Othram Labs, the company used in the Kohberger investigation, creates a DNA profile from the crime scene sample, then uses their shared family genetic markers to locate a common ancestor of the crime scene sample, usually a great-grandparent. A family tree of all of the descendants of that ancestry is then built using traditional means, such as birth announcements, marriage certificates, and obituaries. Once a suspect is narrowed down using this method, a lead is provided to the investigating agency. The investigating agency then obtains a buccal swab from the suspect, and if there is a statistical match, then subsequently an arrest is made. However, there's that 2% variance we heard Othram speak of. What happens if the wrong person from that family tree is selected for the tip? During preliminary proceedings for the Kohberger trial, we heard his attorney, Ann Taylor, repeatedly argue the necessity for her investigators to have access to the list of people identified by the Othram Labs family tree that they produced. The names of those individuals were under a protective order by the court and not accessible to the defense investigators.
So I think what we're really talking about is our investigative team for Brian's case to have access to the IGG materials.
The defendant's motion to allow experts and investigators access to view IGG information.
Reading the state's response, I think the state has no objection to the 3 named experts having access to the sealed IGG materials or the materials subject to protective order. So I think what we're really talking about is our investigative team for Brian's case to have access to the IGG materials.
The likely reason the defense team wanted this list is to investigate if someone else on the list could be responsible for the crime. An impact from a discovery such as this would be powerful in that the defense team could assert someone else in the family tree could be responsible. This would trigger the requirement of the state to perform a new RMP statistic. The suggestion of a family member, even a distant cousin, would have likely required the state forensic lab to produce what is known as a kinship statistic, rather than the standard likelihood ratio that compares the match to the random population.
DNA results are not simply matches or non-matches. They involve probabilities that can be misunderstood. A defense attorney may challenge how statistics were calculated or explained. Overstating certainty can mislead jurors, turning questionable evidence into seemingly conclusive proof. When you use genetic genealogy to narrow a suspect pool down to one family, you have already discarded 99.9% of the general population. If investigators were to pick the wrong person from that family tree, a distant cousin, for example, they would share much more DNA with the crime scene sample than a random person would. Using a general population RMP ignores this pre-existing genetic closeness. If the lab uses a standard RMP, they might report a match as 1 in 5 octillion. This sounds like case closed. However, that number only tells you how rare the DNA is compared to a random person in the world. It does not tell you how rare the DNA is compared to the suspect's cousin.
The prosecutor's fallacy. In McDaniel versus Brown, 2010, the United States Supreme Court has declared expert testimony that amounts to a prosecutor's fallacy is improper. The prosecutor's fallacy is the assumption that the random match probability is the same as the probability that the defendant was not the source of the DNA sample. In other words, if a juror is told the probability of a member of the general population would share the same DNA is, say, 1 in 10,000, the random match probability, and he takes that to mean there is only a 1 in 10,000 chance that someone other than the defendant is the source of the DNA found at the crime scene, what's called the source probability, then he has succumbed to the prosecutor's fallacy. It is error to equate source probability with probability of guilt, unless there is no explanation other than guilt for a person to be the source of crime scene DNA. This faulty reasoning may result in an erroneous statement that, based on a random match probability of 1 in 10,000, there is a 99.99% chance the defendant is guilty rather than innocent. Faulty reasoning that is only compounded when you add forensic genetic genealogy to the equation. By identifying the family tree first, you have created a restricted pool. Using a standard random match probability statistic after using genetic genealogy is often seen as statistically dishonest because it ignores the priors, the fact that you've already narrowed down the search to a group of people who are genetically similar. Now, if the lab sticks to a standard RMP, they are effectively pretending they didn't use genealogy to find the person. This can mislead a jury into thinking the match is more unique than it actually is. The lab should technically perform a kinship likelihood ratio that asks, is it more likely this DNA belongs to suspect A or to a relative of suspect A? According to an interview with Fox News, Othram Labs founder David Middleman said that while their early leads in the Kohberger case didn't include his identity, the genetic genealogy search pointed to a multi-generational Pennsylvania family mixed with Italian ancestry. So that means that through genetic genealogy, Othram Labs removed 99.99% of the entire population of the world and focused in on a small geographic area in Pennsylvania and a family lineage in that area. In the beginning of this video, we talked about a possible recipe of disaster in this case. The evidence suggesting likely DNA degradation. The use of the wrong statistic in the case. We also talked about the case of the woman without a face that misdirected investigators in Europe in over 40 criminal cases based on a simple touch of a cotton swab from an innocent factory worker. Both the defense and state experts agree the knife sheath was new and unused. The added step of IgG in this already complicated process that removed the genetic markers of the entire world down to a family lineage in Pennsylvania. Then we look at the location of the factory worker of the K-bar, where no doubt the sheath last touched by one of their factory workers, and it just so happens to be in the same area that Othram Labs' genetic genealogy search pointed to. And the original question must be asked, with the only evidence that has stood the test of time in the Kohberger case being the DNA, is it really enough to bet your life or someone else's life on?